Hello and welcome to the National Security Conversation. It has been 150 years since the British colonial government imposed the Sedition Law, or Section 124 of the Indian Penal Code in India in 1870. Several decades ago, Mahatma Gandhi called Section 124A, or the Sedition Law, the prince among the political sections of the IPC designed to suppress the liberties of the citizens. Jawaharlal Nehru took this sentiment one step further, terming the provision, and I quote, as obnoxious and highly objectionable, unquote, before arguing that the sooner we get rid of it, the better. But his government did not get rid of it, nor has any government so far. If anything, sedition laws are becoming more popular by the day. Former Union Home Minister Rajnath Singh, during the 2019 Lok Sabha election campaign, said, and I quote, if voted to power again, the BJP will make provisions of the sedition law more stringent to check anti-national activities, unquote. In July 2019, the Union Minister of State for Home Affairs, Nityanand Rai, told the Rajya Sabha, and I quote, there is no proposal to scrap the provisions under the IPC dealing with the offense of sedition. There is a need to retain the provision to effectively combat anti-national, secessionist and terrorist elements, unquote. The National Crime Records of Bureau in India introduced a new category of crime in 2017, incidents of violence by anti-national elements. Should India take down the sedition law? Is a sedition law used to stifle free speech and political opposition in a democracy such as ours? Have these laws become a tool in the hands of the powerful to suppress political opposition in the name of national security or public order? In a recently published book, Sedition in Liberal Democracies, Dr. Anushka Singh, an assistant professor at the Ambedkar University in Delhi, discusses this issue in great detail. And I have Dr. Anushka Singh with me to discuss this issue. So welcome to the National Security Conversation, Dr. Anushka Singh. Let us first try and understand what sedition law means as per law. Your excellent book talks about the various conceptions of the sedition law in India. You argue that there is a difference between how the higher judiciary views sedition law and the popular understanding of the sedition law. You also sort of talk about how the higher judiciary views sedition law and how the executive practices it. Do you want to sort of throw some light on some of these issues to begin with?
Okay, thank you. Thank you for having me here. It's entirely my pleasure. I would like to attempt this question in two ways. One, I would want to go unravel the legal trajectory of the law right from the colonial times. Right. And then move to the sociological life of law, particularly in the recent decades that it has acquired. So starting from the first iteration of the law, which came in 1870, the manner in which sedition was defined, it didn't really come with qualifications. The simple definition of sedition in its very first iteration was disaffection against the government, where the word disaffection had not been qualified. But what the section had was an explanation to the main section, which was 124A. And the explanation said that disapprobation of the measures of the government, which meant criticisms of the measures of the government, in order to support the lawful authority of the government against any form of subversion, would not count as sedition. A lot of people who've done work on the archival history and also the various archival records that I've looked at, there seems to be a lot of discussion amongst the colonial authorities about the misinterpretation of this particular iteration of sedition after it had been enacted, where people said that sedition law had failed to actually secure conviction at that point of time because it was probably misunderstood by the judges who were interpreting the law as not being anything short of an incitement to subversion. So because it said criticism to support the government against subversion would not be sedition, The follow-up interpretation of this was that anything short of incitement to subversion would not be sedition. Because of this misinterpretation, which they say in those discourse, in 1898, the law was amended. This happened after Tilak's second trial.
That's
And
right.
in Tilak's second trial, Justice Trachi in Bombay High Court had come up with his
Mm.
own understanding of the law of sedition,
Mm.
where he said that disaffection has been qualified, even though it has not been written in the law. And the qualification is that disaffection imports all feelings of hatred against the government, contempt against the government, enmity against the government, and disloyalty against the government. So these four feelings, so to speak, became markers of what sedition would have meant in colonial times.
Government and not the state. We're talking about government and not state.
Government, absolutely. State doesn't feature in any of the iterations of law. It only features in the section where 124A in IPC appears. So chapter 6 of IPC outlines offenses against the state, and sedition is construed to be an offense against the state just because it appears in that particular chapter of IPC. But the wordings of the law have never used the category of state. So after the 1898 amendment, sedition was qualified as these four feelings by virtue of disaffection being qualified according to these four feelings. In 1962, finally after independence, the Supreme Court, and we should come back to this particular judgment in the course of the interview, because there's a lot that this particular judgment does to the discourse of sedition in independent India. But in terms of the legal trajectory of law, what this particular judgment did was, this was the Kedarnath Singh versus State of Bihar, 1962, was that it added the clause of incitement to violence to interpret disaffection. So the Kedarnath Singh judgment interpreted the word disaffection to say that only if a particular disaffection expression has a tendency to incite violence or disorder in public, then only then can the word be interpreted to be seditious in nature. Otherwise, mere feelings of hatred, contempt, enmity, disloyalty against the government without importing any idea of incitement to violence cannot be seditious. What this judgment did not dwell upon was the fact that the judgment used the word tendency to incite without having qualified the word
Tendency.
when would a particular expression tend to violence was something that was not provided for in the judgment. Unlike other jurisprudence, say the American jurisprudence, where these manipulative words such as tendency or incitement have been qualified. So free speech norms have been evolved to actually elaborate when the tendency would actually approximate to a likelihood of violence to occur. So unless there's a likelihood of a particular expression to result in violence, all liberal democracies by and large agree that that particular expression, however critical it may be, should be accepted. Now that
so you would say that there is a difference between the way the colonial government or the judiciary looked at the sedition law and the post-colonial judicial interpretation of that law in India. Although there is an issue with the word tendency here, but there is a big difference, you would say, right?
Yeah, and I actually want to come back to this point and relate it to the question that you'd asked: what are the various conceptions? The varying degree or the variety in the manner in which sedition has been defined owes to its contradictory antecedents. So on the one hand, 124A, as was defined by the 1898 amendment during colonial times, still finds mention in our IPC. So our IPC does not reflect the 1962 interpretation. Our IPC still says disaffection qualified as these four feelings. But the 1962 Supreme Court judgment linked disaffection to the tendency to incite violence. So now between 124A as written in the law books and between the Supreme Court's understanding of 124A, there is an obvious contradiction. One talks of the necessity of violence for the charge of sedition to sustain, the other talks of mere possession of feelings or expression of those feelings that you possess against the government to qualify as sedition. And the various conceptions that or the various meanings that sedition acquires on ground, which is where I come to the sociological life of law, also owes to this contradictory impulse. Because in my fieldwork and also in a lot of media reports, when you read police's version of what the law means or how they report the case in the FIR, they are strictly sticking to what 124A IPC says, which is feelings of enmity against the government, feelings of hatred against the government, etc. So a lot of times, in majority of cases, actually in almost all the cases that are getting registered as sedition in today's times, there is no import of the tendency to violence, because that particular understanding of sedition, which has come from Supreme Court, hasn't really made its way to the executive use of the law.
So just to understand that, Dr. Singh, just to understand that clearly, for sake of my viewers, you are saying that while the 1962 Kedarnath versus the state of Bihar judgment of the Supreme Court is an improvement of the 1898 colonial law, the executive has not taken that into consideration by amending the law per se. And therefore, that leads to a contradiction in the way the higher judiciary views it and how the executive practices it. Have I got that right?
One, that it won't be the prerogative of the executive to amend it. It would be the prerogative of the legislature to amend the law. But it's definitely the prerogative of the executive to interpret the law as it has been constitutionally laid down by the court, which is what is not happening in the executive domain once the law is being applied. So that's
what are the implications of that? What are the implications of that on the ground? You coming to that?
Yeah. So coming to ground, what one sees is almost a nothingness of meaning in terms of how the use of sedition, the law of sedition is being made. So I would just probably take cases where 124A has been invoked. So there was and some of these are very, very serious cases, and some of these are absolutely frivolous cases that probably require no intervention of law. But let's come to the very serious cases. So sedition was also invoked in the Samjhauta charge sheet. Or sedition has been invoked as adjunct section in a lot of cases where the primary charge is that of terror, where UAPA is the primary charge. Now, what is the implication of using sedition in these cases? Sedition very clearly says expressions that incite violence against the government. If the law is being used in cases that are prima facie terror cases, and sedition is being used as an adjunct charge in absence of any clear expression to be labeled as sedition, what is the implication of this? The implication is that sedition actually becomes a mere auxiliary law or mere extension of a terror law. As a result, what happens in popular imaginings is a conflation of what sedition means and what terrorism stands for. And terrorism, of course, in popular discourse translates as any anti-national activity. So sedition, by virtue of being constantly linked with terror cases, has also acquired the meaning of something short of terrorism, but something that allies itself with those kinds of offenses.
So if I understand that correctly, does it also have the opposite effect, that somebody is charged under sedition with absolutely no links to terrorism per se, but just because a person is charged under sedition, as per how the executive sees it, in the popular parlance, that person is then seen as a, anti-national, as a terrorist, and this and the other, although these are two very different things. Have I got that right?
which is what I was coming to, because the popular translation of sedition, especially in Hindi, happens to be that of Deshdroh, as opposed to Rajdroh, which would have been a literal translation of sedition. Rajdroh is offense against the state. But because sedition gets translated as Deshdroh, which is offense against the nation, even though it's not really a case of, say, a terror attack or a terror conspiracy, by virtue of importing the meaning of anti-national, which has got aligned to the use of law of sedition, the seditionist gets labeled as anti-national,
Right.
which is what the sociological life of law has
Right.
come to apply.
Right. Anushka, I want to sort of go back to the colonial period. On page 173 of your book, you say that on the one hand, there was a category of people that claimed to be anti-national, anti-colonial, nationalists and freedom fighters, but did not claim to be seditious, accepting its offensive status. On the other hand, there were those self-proclaimed seditionists advocating the breach of law. It was a latter category of freedom fighters who actually evolved a different understanding of the act of sedition, liberated from the vocabulary of the state to mark the rightful claim to dissent. Now, you seem to, I think your book seems to say that Tilak belongs to the former category, whereas Gandhi belongs to the latter category. Why is this distinction useful in your understanding, in sort of understanding how the discourse around sedition law evolved over time?
This distinction is very, very useful pertaining to the contemporary use of law, because once the popular imaginings has accepted sedition as Deshdroh, what has happened is the content of political from the law has diminished. So what is anti-national does not in popular imagery translates as rightful dissent, because rightful dissent would be an extension of your constitutional right to dissent, which is, by default an extension of your fundamental right to freedom and expression. Anti-nationalism, or any expression that is now being construed as anti-national, of course would not fit into the framework of Article 19. This particular distinction, which is actually a result of the post-colonial struggle, where sedition had come to acquire that kind of political connotation, where sedition was an act of patriotism, because sedition was resistance to unlawful authority, which was the colonial state at that particular time, is something that has been lost after independence, also in the beginning decades also, but more so in the contemporary use of the law, because sedition is not being associated with an act of resistance against the government, or as an act of protest against the government, because the understanding of sedition is not that of an offense against the government. The understanding is immediately that of an offense against the nation, because the popular translation is anti-national. That's why this particular distinction is very, very useful and needs to be reiterated again and again, so that the distinction between political dissent and anything that is anti-national, so to speak, which is against the nation, against the people. Anti-national is not necessarily against the government, it has to be against the people. Gets clarified more so, and the boundaries are not diffused to label what is anti-government, to label it as anti-people.
Right. Dr. Singh, you do talk about the Constituent Assembly debates about the sedition law. In fact, the sedition law was used widely to stifle the voice of the Indian freedom movement during the colonial period by the British colonial states. It would have been natural for the Constituent Assembly and those who fought the freedom struggle after independence to sort of ensure that the provision 124A was removed from the IPC. But unfortunately, that did not happen. People like Sardar Vallabhbhai Patel and Rajagopalachari, they ensured that this law remains in the Indian Penal Code. So how do you sort of see that debate early on in India's history, in the Constituent Assembly in particular?
The Constituent Assembly almost seems to be divided on the question of whether the law should be retained at all in any form, whether in IPC or as a restriction to Article 19, freedom of speech and expression in the Constitution. So there were people like K. Munshi or Damodar Swarup Seth, Krishnamachari, who were of the opinion that the very presence of this law would hinder the exercise of right to freedom of speech and expression. And then there were, of course, the kind of people that you named who were insistent on retaining the law because this law was believed to give the state some kind of a shield. And this was a nation, a nascent independent state which probably needed protection from quote unquote reactionaries. That's the word the Constituent Assembly uses in order to defend the law. But gradually the debate moves to a particular direction where even those people who were absolutely against retaining this particular law were sort of happy with the compromise that the section is removed from the restriction on fundamental right to freedom of speech and expression, but retained in the IPC. The implication was that you don't make sedition a constitutional limitation on the exercise of freedom of speech and expression. So no government is justified in using the law of sedition directly to restrict your freedom of speech and expression. But the law remained on the statute, which means that incitement of disaffection against the government is a penal offense in India. So you're saying two things at the same time. That if you incite disaffection against the government, you are committing a crime. On the other hand, if the government uses the law of sedition to restrict your freedom of speech and expression, the government is acting unconstitutionally. Now, there is very clearly a contradiction here because on the one hand, the government is not allowed to use the law of sedition as a constitutional limitation. On the other hand, sedition is an offense in the country. This translated in interesting judgments in the early decades prior to the first amendment in 1951. So in 1951, 3 Supreme Court judgments where the State Public Order Acts have been used.
When was that? Sorry, I didn't get the year.
Sorry?
Which year was that?
1950. Okay. In fact, on the very same day, I think it was one of the days in May 1950 that two particular judgments came from Supreme Court. One against an RSS mouthpiece organizer, and the other in case of a left publication, Crossroads, which was published by Ramesh Thapar in Madras. The RSS mouthpiece was published from Punjab, and the left publication was from Madras. In both these cases, the Public Order Acts of the respective states had been invoked to censor the publications, saying that they've been publishing seditious material. And the Supreme Court in both these cases ruled, taking, of course, a very, very neutral stand, a pro-RSS publication stand and a pro-left stand at the same time, saying that if these pieces are publishing seditious literature and the law that you are using is a Public Order Act, then there is no necessary connection between sedition and public order. And sedition is not a constitutional limitation on freedom of speech and expression.
Right.
So in order to allow the Public Order Acts to restrict seditious literature, you have to first prove that sedition poses a danger to public order. And in absence of any clear linkage between the two, sedition cannot be allowed, or publication of seditious material is not enough a ground to prosecute these pieces, which was followed by the 1951 amendment, where the clause of public order was inserted in the section on reasonable restrictions to exercise of freedom of speech and expression. And then you have a series of judgments where the debate is on whether or not sedition is impacting public order or not. And finally, it was in 1962, and that is why I said we need to keep coming back to the 1962 judgment. Finally, in 1962 judgment, the Supreme Court said that sedition has to be interpreted as incitement to violence and public disorder, which meant that the clear linkage has been established between sedition and public disorder. So if sedition is, or if disaffection is being interpreted as incitement to public disorder, then that means that sedition is clearly an offense against public order. And if sedition is an offense against public order, then even though sedition is not a reasonable restriction on Article 19, by virtue of public order being a reasonable restriction on Article 19 and sedition being an offense against public order, sedition becomes a default restriction on the constitutional exercise of freedom of speech and expression.
That is right.
So this is what the politics of the judgment was. It actually saved the law from getting nullified, from being declared unconstitutional, which was actually the matter of debate in one of the judgments that came just before 1962, a very progressive judgment that came from Allahabad High Court in a case against Ramanandan, a communist, where the constitutionality question of sedition had been raised, and the judgment said that sedition is not a constitutional limitation because there's no clear link established between sedition, public order, and security.
Interesting. Anushka, so where did the Congress, what is the track record of the Congress party and the first Congress Prime Minister Jawaharlal Nehru on the issue of sedition and charging of individuals under the Sedition Law post-independence?
So again, competing impulses. So on the one hand, the First Amendment was being moved to insert the clause of public disorder, and it was more than apparent that public order was being inserted as a clause within reasonable restriction to make sure that laws like sedition get covered within its ambit. On the other hand, while defending the First Amendment in the Parliament, Nehru is saying that take the example of a law like sedition, and I'm of the opinion that the sooner we get rid of this particular law, the better. So the face of the government seems to be very, very pro-free speech, but unfortunately the actions weren't. So right from the First Amendment to say the 16th Amendment that came in 1963 in the wake of the rising secessionist movements, which again inserted another clause in the section on reasonable restrictions, which was in the name of sovereignty and integrity of the nation, which means that any speech that challenges the sovereignty and integrity of the nation, that speech is also not covered is not protected under the freedom of speech and expression. And then there are many cases where the Congress governments, both in states and at the center, has used the law of sedition. And most of these cases happen to be cases against the communists. Barbara Rao's wife was running a journal called Srijana in Andhra Pradesh. That particular journal was prosecuted. She was prosecuted for publishing that particular journal. And the charge was publication of seditious material. There was a case of, again, prosecution of a communist publication in Madras, where somebody had published a translation of a book written by Mao. It was only a translation, but the logic of charging that particular publication with sedition was that in translating the writings of Mao, the intention of the publisher is advocacy of overthrow of the government, because Mao believes Mao's conviction is overthrow of the state. So the track record clearly is not very clear, and not even in the recent times. 2014 is the first year when NCRB comes up with the data on sedition, and there are 47 cases of sedition that were filed in 2014, and that's before the BJP government came to power.
Right. In your book, you write about the notion that the legal consequences of sedition charges have to be seen and understood in the light of the social consequences on individuals, organizations, and movements. So, what are some of these consequences in your sort of understanding? Because I think you should be making a very clear argument here that the courts have it. The higher judiciary has a higher standard when it comes to their understanding of what qualifies as an act of sedition, whereas the lower judiciary or the executive seems to have a more sort of charitable interpretation of it, and this has implications, consequences on individuals, organizations, and movements. So, how do you sort of explain these consequences in a brief sort of manner?
So, if I understand you correctly, there are two questions. One that relates to the effects of law outside of the legal sphere.
Right.
And second is how far the discord between the higher judiciary and the lower judiciary and the executive put together impacts this kind
That's
of the social life of law. So on the first, there are very, very clear implications, which again relates to how sedition is being popularly understood on ground. So if it clearly has attained a character of an act being anti-national in nature, the social consequences that follow are very clearly that of delegitimization of the activities of the individual or the associations that he or she is associated with, or ostracization from the community, or even if there are people who are sympathetic, there is clearly a distancing that happens, because what is seditious is not just an act of dissent anymore. What is seditious is something that literally translates as quote unquote a deshdrahi. So that's the kind of social life that the law has attained. But when it comes to the discord between the two state institutions, the executive and the judiciary, and the lower judiciary siding mostly with the executive, one that I want to be cautious and not make an elitist argument that it's the higher judiciary that understands the law better and the lower judiciary doesn't. I'm not making that kind of an argument. The only thing that I'm saying is that the lower judiciary happens to be enmeshed in the local power dynamics much more than the higher judiciary is. And sedition is a political law, very, very clearly. And there are examples of use of sedition against members of the opposition or any particular constituency in the state or at the local level, which is not clearly by the side of the government. For example, I'll take the example of the Bharatiya Kisan Union in Haryana in the early 2000s. INLD was in power, and Ghansi Ram, as the leader of Bharatiya Kisan Union, had led a strong Kisan movement against INLD, Om Prakash Chautala, at that point of time. And there were mass charges of sedition leveled against the supporters of Ghansi Ram. Ghansi Ram was jailed, etc. When Congress came to power, of course, before coming to power, the entire campaign of the Congress in Haryana in that election was centered around releasing Ghansi Ram once it comes to power and fulfilling all the demands of the Kisan Union at that point of time. And once it came to power, all the charges of sedition were withdrawn and Ghansi Ram was released. So very clearly, it's a political law. Now, what happens is that when the executive is using the particular law to fulfill a politically motivated cause, the lower judiciary is not absolutely sitting outside in a vacuum outside of that local power nexus. The district judge is not someone who is completely, and I may be, really critiqued by a few district judges for actually calling them partisan, which I'm not trying to say. This is something that I've just seen in my field work, that the lower judiciary seems to side with the interpretation of the executive at the local level. So in the various court orders that I've read that have come from session courts, the judgment is almost replicating the FIR story, which means that the judge is not applying a definition of sedition which flows from the 1962 judgment, even though it's not really an adequate definition.
Have there been examples on the other side of the spectrum? Have say High Courts or Supreme Court come out come down heavily on the executive for not sparingly using the sedition law at all?
So heavily, I don't know how to quantify the term heavily, but there are two cases that I can cite. One was the very publicized case of the cartoonist Asim Trivedi, who was charged for some of his cartoons. And some of his cartoons were, his cartoons didn't really attack a particular government, so to speak, but his cartoons were using national icons, so to speak, and they were trying to build caricatures of the national icons. So the Ashok Chakra was shown as the tigers in the Ashok Chakra were shown as wolves, or the parliament was shown as being infested with robbers or rapists, dacoits, etc. So he was probably taking fun at the kind of politicians we have, and he was charged for sedition. And of course, there was a big campaign against the misuse of law, etc. And he was released, and the charge was taken back. But Bombay High Court, in quashing the case, had come down, so to speak, heavily on the executive interpretation of the law and reiterated that the 1962 judgment has qualified sedition as incitement to violence, and unless there is a clear incitement to violence, the law should not be used. The other example is when Murugan Gandhi was charged for sedition, and this was in Kerala, if I'm not wrong. And again, the court found that that was not sustainable and it was taken back. After the charge was taken back, the DGP Kerala had issued a directive to all police officials in Kerala saying that you have to conduct a primary investigation before applying the section 124A, whether or not it fulfills the constitutional criteria of invoking the law. So, except for these two, there haven't really been too many instances. But I do want to talk about one particular thing, which is that even though the higher judiciary stuck to the 1962 interpretation, there is absolutely an unwillingness of the higher judiciary to engage with the ambiguities of that particular judgment, 1962. So, for instance, I think in 2016 or in 2015, Prashant Bhushan had filed a PIL in Supreme Court in the wake of mass charges of sedition against the Kudankulam movement, the anti-nuclear movement. And he had said that it's the 1962 interpretation that's constantly being violated. And what the Supreme Court needs to do at this point is to issue directives to the executive on how to use the law. And the Supreme Court had dismissed the PIL saying that we don't need to re-engage with the issue, and the 1962 order stands as the authoritative order. So the ambiguities that the 1962 order is producing, whether it's the incomplete definition of the word tendency, or the misunderstandings of the meaning of disaffection in the executive domain, these are things, very serious concerns that the Supreme Court is not willing to engage with, which is then also making the Supreme Court complicit in, so to speak, the misuse of law, even though it is not misreading the law.
Right. Dr. Singh, compared to other offenses, sedition remains a rare crime in India, accounting for less than 0.01% of all IPC crimes. However, within India, some states are, could be seen as sedition hotspots, as it were. Assam, Jharkhand, for instance, these two, I think, account for about 32% of all sedition cases between 2014 and 2018. What does that mean? So you first have Assam and Jharkhand, then you have Haryana, Bihar, and Kerala. In this case, so how do you look at the geographical sort of distribution of the sedition cases in India? Is there any insight coming from that at all?
So I don't think that it follows a pattern. What happens is that sedition becomes a popular charge against a particular movement in a particular context. So in Assam, it's the anti-CA movement. So if you see the data on Assam, it's the year 2018 where Assam has the maximum number of cases. This also includes the popular charges against Hiren Goen and Akhil Gogoi and all of these people. If you see the data for 2017, it's Haryana, which emerges as the hotbed. Why Haryana? Because that's the time when the pro Jat reservation movement was charged for sedition. So what happens is that if there's one particular movement that begins inviting the charge of sedition, there are about 10 odd FIRs that are filed in relation to specific people associated with that movement. In Jharkhand, it's again the Pathalgadi movement that's invited the charge of sedition. So I won't say that there's really a pattern, and I am absolutely not making an argument which hints at the use of the law more by a particular government and less by a particular government. It's a law that has been used indiscriminately by all governments in power. The pattern of its use, again, under the current regime, is that there is an unprecedented proliferation of charges related to sedition in quote unquote anti national expressions. And that's where the most dangerous law follows, because once sedition acquires the anti national connotation, it can be used in case of anything and everything. So there are cases where sedition has been used for against young boys who were wearing T-shirts called ISIS, which they picked up from local market, and the charge was actually withdrawn almost a week later. And these were boys who could not even read what was written. These are, of course, unintended sort of acts where you invite the charge.
Dr. Singh, that actually takes me to my next question, which is, I read this report recently that in 2020, since 2016, only 4 sedition cases have seen a conviction in a court of law. So as you're saying, many of this charging is basically frivolous in nature. So is it because the state is charging people frivolously that they don't see a conviction in the court? Or is it lack of evidence? How do you sort of explain the very few convictions in a court of law?
I actually believe that the frivolity of charges represents only a minority of cases. In most cases, the charge is an intended use of law. So so it's not that the police went after these boys wearing ISIS t-shirt because the police wanted to prosecute the boys. The police wanted to send across a message that wearing ISIS is anti-national. The boys happen to be inadvertent about it, but then there are a lot of people who are not. So if there is a quote on Facebook saying I support Pakistan, it may not be an inadvertent act. The question is whether saying I support Pakistan means that you are inciting violence against your own government. Now that's not what the law says. Or I remember the case of that of actress turned politician Ramya would come back from Pakistan after a SAARC summit and said Pakistan is not hell and the people are actually really nice, and there was a case of sedition filed against her. So if so in the what's happening in the use of law in the executive domain is that anything that is deviant from what is the accepted nationalist conduct, quote unquote normative nationalist conduct, invites the charge of sedition. So nationalism no longer is pride in your own country, but nationalism also means that you can't say anything that is praiseworthy of the enemy, the supposed enemy of your country.
Right, I understood that part. What I'm trying to get at is that the very few charges have seen conviction in the court. How do you explain that?
So one that the pendency percentage of court disposal of cases is very high. So every year there's almost 80 to 90% pendency rate of FIRs filed. So it's not that most cases
Across all
are
cases.
actually
Across
across
all
all
cases.
cases. So it's not that out of say 70, so in 2018, 70 cases of FIR, 70 FIRs were filed under sedition. But the total number of cases that were taken up for trial were only 13. Now, out of 13, 11 resulted in acquittal and 2 resulted in conviction. Now, that 11 versus 2 ratio also goes on to say a lot. But what is still absent is that out of these many cases, only 11 were cases where trial was completed. So it's the process that's the punishment more so. So falling
That's
rate of conviction on the one hand, of course, says that these are charges that deviate from the established understanding of law and hence are unsustainable in court. And of course, that's a very, very dominant argument that these are unsustainable charges that are being leveled at the level at the.
but this I understand. This also means that the judiciary is cognizant of the fact that much of what goes on in the name of sedition, or much of what the government does in the name of sedition, is unsustainable. The judiciary is cognizant of that fact. That needs to be.
Yes.
Right.
Yes,
You do
but
talk about. So go ahead.
I don't think that courts take a position that just because a law is being enforced, that law should be read down
Yeah.
or declared unconstitutional. That's not
Yeah.
the stand that comes from the official discourse.
Yeah.
So the
Sure.
misuse of the law is not enough a reason for the judiciary to sort of relook at it.
Right. You also, and you mentioned this earlier in one of your answers, you sort of term sedition is an exercise in imposing normative nationalisms. You sort of alluded to that earlier on. Do you want to explain that a little more?
So I would want to approach this question from again the kind of example that I was citing. So if cheering for the victory of the Pakistan team invites the charge of sedition, or saying I support Pakistan, or liking a particular Facebook post which supports the neighboring country, etc., invites the charge of sedition, then what is happening is that an entire discourse of majoritarian nationalism is being constructed, where the conducts of what would be a national act and an anti-national act are very, very clearly laid down. And any deviation from what is popularly constructed as national invites the charge of sedition. And it's only the adherence to, and the majoritarian discourse of nationalism is what I call the normative discourse of nationalism, because it's become the norm. You have to conform to what is nationalism in accordance with that majority within the contours of that majoritarian discourse. So that's become the driving point of the use of the law. And again, so to speak, the national icons are very, very important in this particular discourse. So whether it's the national anthem or the national flag or the national emblem, so not standing up for the national anthem invites the charge of sedition, even though if at all it should be a concern. The Supreme Court's come down heavily on it after its earlier guideline. But if at all it should be a concern of law, it should be a concern of the National Honor Act and not the law of sedition. But unfortunately, most of the cases of sedition today relate to offenses against these quote unquote national symbols. So the driving point of the discourse of nationalism are these national symbols. But what is very interesting and what gets often left out in the entire debate is that all of this is happening to invoke a particular law that was meant to be an offense against the government. So what is happening is that a law which was meant to be an offense against the government is being used against anything that is anti-national. And the conflation by default is then between the government and the nation. So government becomes the nation. So anything that is seditious becomes anti-national.
I'm trying to understand the relationship between various anti-terror laws such as UAPA and 124A, which is a sedition law. Because I mean, quite unclear about it. There's a lot going on about, sedition, anti-national, etc. And there is also a lot going on in the name of terrorism. And in the public imagination, people look at someone who is accused of sedition as an anti-national, as a terrorist, Deshdrohi, etc., etc. So, is there from a technical legal point of view, is there a relationship between 124A and UAPA and other anti-terror laws such as the UAPA?
Okay, so there are two particular patterns that the alignment of 124A with anti-terror laws follow. One is the conjoined use of both laws in the same case. So in a UAPA case, 124A would also be used as an adjunct charge, which then of course then diffuses the meaning of sedition because it's now associated with the terror case. And second is provisions of anti-terror laws reproducing offences that can also be ordinarily charged under the under 124A. So UAPA, for instance, penalizes disaffection against the government under Section 2O. That's also the offence of sedition. But UAPA gives a wider reach because it's not aligned to a clause of incitement to violence. Now, in my work, I've seen three kinds of patterns of the relationship between anti-terror laws and sedition. One, that the use of anti-terror law may completely obliterate the possibility of invoking 124A in a particular case, because UAPA would help the state achieve a lot more than what sedition would, because it gives you wider power, it gives wider power to police, it dilutes safeguards of CRPC in courts, etc. Second is that UAPA has a provision of enhancing punishment if the accused is found flouting rules under other sections as well. So if UAPA is used along with 124A, then the provision for enhancing penalty sort of increases. And a lot of times, the charge of literature in a terror case invites the offense of sedition, and the larger conspiracy charge invites the UAPA. The third is that UAPA may not be invoked directly in the primary framing of the particular case. So sedition may be a primary charge, and later on with investigation, UAPA is invoked because the police goes on to find out that there's a larger conspiracy at work, etc. So sedition then is used as a base charge. Now, this is something that has happened before UAPA, the amendment to UAPA in 2004, with regard to other anti-terror laws also. So, for instance, when TADA was being used against the Khalistan movement predominantly, the the supporters of the Khalistani movement for sloganeering or carrying out processions, for even listening to cassettes which had recordings of Bhindranwale, etc., were charged under TADA, and the particular section which dealt with expression invited the charge of sedition. So there are cases, I remember very clearly, Balbir Singh versus State of UP, where the person was charged under TADA section 4 plus sedition, because that person was caught listening to the cassettes of Bhindranwale, and the Supreme Court had come down heavily against the police, saying that listening to something doesn't mean performance of that particular expression. So it's not a sustainable charge. So that particular use of sedition we've seen in context of TADA. In context of POTA, again, POTA plus sedition against Simi activists, against all other cases where the primary charge was that of jihadi terror, where speeches of particular organizations who were banned or a ban was being contemplated on these organizations invited the charge of sedition. So whatever literature they published invited the charge of sedition, and the larger conspiracy invited the charge of POTA. So that's the kind of conjoined use that one has witnessed, and which in effect has, of course, led to a dilution of what sedition means, because it has no individual character in these cases. It becomes just a follow-up charge within terror.
Right. Those who support laws like the Sedition Law would argue that India is a country that faces multiple challenges, both internal and external, from nationalism to insurgency to terrorism. And there have been multiple terror attacks in India, both in Kashmir and in other parts of India, Mumbai, Delhi, etc. So we need stringent laws of this kind. Because we're still struggling to deal with some of these very, very major challenges. What would be your response to that? Would you say that you can deal with these issues using other laws, and we don't need sedition? What would be your answer to this kind of a counter to or support to sedition law as it were?
So these are exactly the kind of arguments that were used in Constituent Assembly for the retention of the law of sedition. And the belief was that a democratic country, unlike the colonial state, would not misuse a provision and would only target the reactionaries, the so-called the enemies of the state, the internal enemies of the state. What is completely missing the debate is the aspect of control that political authorities have over offenses that are defined as offenses against the state. So sedition is a law which is giving political authorities the power to prosecute any expression that they think is seditious in nature, because the interpretation of what is seditious, at least at the level of invoking the particular section, is with the executive. And it's also an offense against the executive because it's defined as an offense against the government. And government, of course, in political science, we sort of relate government to executive. Judiciary comes much later into the scene when it comes to the interpretation of whether or not the FIR was sustainable or the charge sheet sustainable or not, the charges. So judiciary is coming much later. It's the executive that has the power to use the law. And it's also the executive that has the power to decide who should it use against. And it's also the executive that becomes the victim of the law. Unlike other criminal offenses, where it's not the executive that's the primary victim of the law. Even in a case of murder, state is the plaintiff, but not directly the victim. But here it is. So once the government or the executive is willing to assume that kind of victimhood from, say, a seditious expression, the charge of 124A is invoked into that scene. So what is completely missing the debate is the kind of power that laws like sedition are giving to the executive, where in a democratic setup, people's representatives have the power to use a particular law against the people who have made them people's representative. So that aspect distinguishes sedition from other laws that are laws meant to coagulate the national security. So sedition is really just about mere expressions against the government.
So put differently, would you say that in order to deal with the other contingencies of national security, there are enough laws that are in existence? You don't need a law like sedition. Is that the argument?
I'd like to believe so, because eventually what a law like sedition would do is continue to empower the state government to penalize expressions that it wouldn't want to hear. That's in effect what the law achieves. Incitement to violence is different. Incitement to violence also in a more qualified jurisprudence would mean really an offense that preempts physical act of violence, which is not what sedition does. Sedition originally is just about a certain kind of really deep criticism of the government.
Dr. Singh, wonderful talking to you. Thank you so much for coming on the show.
Thank you. Thank you.
To receive instant updates on all videos from The Wire, click the subscribe button and hit the bell icon. Pay to support independent journalism. Click the link in the description and choose the amount you want to pay.